seconds to go. Start. It shall not be deemed to be lawful within the meaning of this rule. A plain reading of the above provision clearly provides that for a valid compromise in a suit, there has to be a lawful agreement or compromise in writing and signed by the parties, which would then require it to be proved to the satisfaction of the court. In the present case, there is no document in writing containing the terms of the agreement or compromise. In the absence of any document in writing, the question of the parties signing it does not arise. Even the question of proving such document to the satisfaction of the court to be lawful also did not arise. Thus, it cannot be said that the order dated 20th August 1984 was an order under Order 23, Rule 3 CPC. Once it is held that the order dated 20th August 1984 was not an order of compromise of suit under Order 23, Rule 3 CPC, the argument relating to applicability and bar under Order 23, Rule 3A CPC would have no relevance at all. Additionally, we must also note the case of Somdev versus Rati Ram as presented by the appellants to clarify the rigors of Order 23, Rule 3 of CPC. In this case, it was clarified by this court that after the amendment of Code of Civil Procedure in 1977, a compromise decree can be passed only on compliance with the requirements of Rule 3 of Order 23, otherwise it may not be possible to recognize the same as compromise decree. When a compromise is to be recorded and a decree is to be passed, Rule 3 of Order 23 of the Code requires that the terms of compromise should be reduced to writing and signed by the parties. In the present case, neither the compromise deed has been reduced to writing nor it is recorded by the court. Mere statements of the parties before court about such said compromise cannot satisfy the requirements of Order 23, Rule 3 of the CPC. Therefore, the compromise decree is not valid. In view of the above analysis, the present civil appeal is allowed. The orders passed by the High Court and First Appellate Court are set aside. The judgment and decree of trial court dated 19th December 1992 dismissing the suit is confirmed. Pending applications, if any, are disposed of. The appellant's defendants preferred a regular second appeal number 55 of 2002 before the High Court. The High Court, by the impugned order, dismissed the same and confirmed the decree passed by the First Appellate Court dated 21st December 2001. The High Court held that execution of sale deed does not either abrogate, detract, or dilute the effect of a previous conclusive determination. Stop.